Good morning and welcome to the ILG webinar, Public Health Law in North Dakota's Local Public Health Units. Thanks for joining us. My name is Alicia Adolf and I'm the Professional Development Manager for the Association of Counties. And today you'll earn one ILG training hour. And for any state's attorneys attending this webinar, it is CLE credit approved. And like always, you have that chat box where you can type any comments or questions. And at the end of this live webinar, a quick evaluation is going to pop up on your screen, and we ask that you give us your feedback, which is always appreciated. So let's dive right in. Presenting today from the North Dakota Association of Counties, we have Executive Director Aaron Burst. Good morning, Aaron.
Hey, good morning, Alicia, and good morning, everybody listening. I appreciate the opportunity to be out here. And a couple of housekeeping things before we really get cranking. This just got put on the calendar, but if you look at May 13th, I believe it is, we now have a PERS webinar. So go ahead and go on to the North Dakota Association of Counties website and take a look at that. You're going to want to sign up for that. As I've mentioned before, all your new employees starting January 1 of 25 will be on a PERS defined contribution plan, which is a significant change to county government. Well, actually all government, state and local. So please take a listen to that. So and then the other thing I was going to mention before we really get cranking on some of this is the whole genesis of this presentation was the Association of Counties for the last year or so has been working with Department of Health, DHHS, on putting together a manual that would go out to the local public health officers and commissioners or whoever sits on there or whoever wants to look at it in general. The concept was it's been a while since we put kind of a manual together or done some training on public health. And so luckily enough, DHHS provided us some funding to have some interns that started putting a manual together the last year and a half. So I just want to thank Tyler Johnson, Claire Erickson, Lindsay Prouty for their work on this. They're acknowledged in the document itself. We were hoping to have it available, but it still needs, it's 95% complete, but it still needs a couple of things that I need to check, a few of the statutes to make sure they got updated correctly, and a few of the typing kind of stuff, the spelling and those kind of things. So it's almost ready to go. As soon as we get that ready, we will make it available on the website, or give me an email, shoot me an email, or Mary Korsmo an email, and we will get that out to you. So I'm excited about that. As I was prepping for this presentation, public health covers so much, and there are so many chapters you have to look at, and it's not just local public health, and it's of course the folks at the state and all of those different authorities. So there's no way in 1 hour I can get through absolutely everything on local public health. So this is supposed to be more of a snapshot of kind of what the manual will be encompassing. The manual is, in our view, going to be a living document. As things come up, we're going to stick new things into the manual. So again, we have the skeleton put together on some of the major issues that all of you face on a day-to-day operation. And then we will be putting in more stuff as common questions come up. So I'm happy to report that that's going to be kind of pretty cool. And then Dr. Wiebe, I don't know if you'll ever hear this, but I do appreciate all that you've done for local public health. You've been a great partner, and look forward to working with you more in the future too. Okay, so there is a little bit of kind of the thank yous and get started. Of course, my disclaimer on most webinars I do, sometimes I forget, but on most webinars I will always mention I am legal counsel to the Association of Counties, or executive director, I guess, of the Association of Counties. If you have specific legal questions, only your legal counsel, whether it be on the state side at the AG's office or a state's attorney or a local city attorney, only they can provide you actual legal advice. That said, I'd be more than willing to sit down with them or you to explore concepts that you're having and work through those issues to make it as easy as possible. I've said this to the local public health group. But I think local public health is the wave of the future. More and more citizens are demanding making sure that whatever services they receive is good and healthy, and that's going to be a huge role in the future. Now, I obviously know the big elephant in the room. We came through obviously a pandemic, which was horrendous, which is, by the way, a large part why we do webinars, because it turned out pretty convenient to do. I still like to do these presentations in person, and so please still come to the personal conferences. But the elephant in the room is public health has been under the gun for the last couple of years for, of course, the COVID and the vaccines and all those kind of things. And I think that indeed was unfortunate because I think a lot of people forgot how important public health is, and they only think of public health in terms of the pandemic, which everybody was just trying to do whatever they could to make sure people are taken care of. So it's unfortunate that we had kind of some bumpy road there, but I'm feeling pretty good that we've got over those humps, and now we can get back to focusing on general public health, which everybody eventually will recognize is very important. Okay, so the current structure in North Dakota of public health is kind of awkward, and I guess sometimes centralized government isn't always the best, and completely localized government isn't always the best. So you probably have the best of all worlds right here. The current structure is we have 6 tribes that have their own public health units, and then you have a smattering of different styles in the counties and the cities. And this is the current structure. You can see there's multi-county districts. You can see that there's counties that have just their own department. You can see that some counties have their own district, which is a little weird. I've never quite figured out the benefit of having just a single county health district. The whole process of a district is to combine forces with somebody else, but it works, so that's totally fine. And then you have cities that, for example, in Burleigh County City runs the public health unit, but then the county contracts with that public health unit of the city. So again, there is no right or wrong here. They all work. If the locals all find that they're getting the services correctly, then more power to them. We will get into some of the processes of how you put those districts together or take them apart. But generally, this has been stable for quite some time. I know there has been a few county departments that were interested in creating a district, but it's not necessarily as easy as it should be. So just a little kind of background on our civics lesson for the day. Anytime you're using public funds, that requires electors. Of course, as you know, nobody has a choice whether to pay taxes or not. If they are taxed, they must pay, or potentially they could even go to jail. So, of course, when the Queen of England or the King of England decided to charge the colonists on their tea and their booze, people got really upset because they didn't have a representative in English Parliament, and through a revolution, which created the United States. So there is a strong value in the United States that anytime taxpayers are required to pay for something, they have to be represented, and that had to be an elected official that makes that decision. Now, a lot of times people won't be happy with that elected official, but at least they have the opportunity to vote for that official or the official's opposition. So that is really the basis of how we create these districts. Now that's then sometimes kind of conflicts with how we set up a district. The concept of a district or a multi-jurisdictional type of jurisdiction is that you use resources from 2 counties or 3 counties or 5 counties or a city and a county, and you combine forces to make it more reasonable for everybody in that jurisdiction and more efficient. That sometimes poses some problems, and I'll get to this in a second. But that means, again, if you're going to honor the no taxation without representation, you need to make sure that you have the elected officials ultimately making the decision on how much to pay. So a little bit continuing with the public health structure. And again, Alicia is available for comments. Feel free to jump in at any time. And then we'll just pause every so often to see if there's any particular comments.
Sure.
Now,
Erin,
I have seen that. Oh, yeah.
did you want to take a question?
Oh, we got a question already. Yeah, you bet.
I do. If you want to answer it now or if it's coming up in the presentation. But Erin, the question reads, who acts as legal counsel for the districts? Do they need to hire their own attorney or do they work with the county city attorneys or AG's office?
Yeah, great question. So there is a statute that says the Department of Health shall provide guidance to the local public health. So I know for many years, Mike Mullen at the AG's office was providing legal advice to a lot of the jurisdictions. That said, I do believe it still falls within the state's attorney's jobs or the city attorney's jobs to help direct those comments. Now, again, this is why it gets a little, every time you start blending, state people, county people, city people, it's not as clean, which I should have mentioned this in the presentation. If there's anything you take away from this, because you have such a decentralized public health system in North Dakota, and for that matter in the United States, it's critically important that the communication lines remain open because just for efficiency purposes, if the AG's office is working on a particular issue for public health, it makes no sense. The state's attorney would also be barking up that tree. So you really got to consolidate some of those decisions. That said, if anybody is getting legal advice to a county, that has to go through the state's attorney. Now, in my experience, most state's attorneys are so busy that if a local public health officer goes to the AG's office and says, hey, can you help me? The state's attorney will say, knock yourself out. I appreciate the AG's assistance. But that being said, you really do have to make sure you communicate with the state's attorney to know that they are getting some legal advice from somewhere else. So the bottom line to that is it's not particularly clear, although ultimately it will come down to your jurisdiction's legal counsel has the ultimate say, unless they transfer that or allow that to happen. But I know that the AG's office has been very helpful, at least in the past. That's a great question. I struggle with that one a lot too.
And then just a comment to follow up, somebody had commented in that we hire an attorney familiar with labor law for HR questions.
Yep, and so that's totally acceptable, except you can't hire legal counsel in particular for any jurisdiction without first going through that legal counsel. So for the example, if let's say a single county unit is having HR issues, technically the state's attorney can just say, go ahead and knock yourself out, hire that counsel. But technically it has to go through that state's attorney to give the permission to use outside counsel. Which again, every state's attorney I know is already swamped with criminal cases. So if you're saying, hey, we'd like help on the HR, do you have a problem of us hiring an attorney? No state's attorney will say no. In particular, when it comes to HR, because that can, as everybody knows, just be an absolute time suck. So I have no problem with you hiring them, but I would like you to check with your legal counsel to make sure there's permission, is the answer to that question.
And can you or multiple states attorneys for multi-county health units?
You could. How that generally works is those states attorneys would have to get together and generally come up with, hey, who's going to be handling this issue? I'm totally cool if you're going to do it, but I just want to make sure somebody's handling it. Now, when we talk about county social services, as all of you know, that's county-based, but we went to a zone model instead of 53 different county directors. That's specific in the law then. When we did that change, is there would be an identified host county. So wherever the host county is, so we know where the buck stops. The host county would provide the legal services and the the payroll and all those HR kind of issues. That was the whole point of consolidating that, so you don't have to wonder where the buck stops. That being said, a host county state's attorney could say, hey, you know what? The attorney in this other county is very good at HR. I'll do all their DUI cases if they agree to do the HR. So you could still work out where a state's attorney is the host county, quote unquote, state's attorney, but they're passing it off to somebody else. That's why, again, I think probably someday for public health, we should identify that so we at least know where the buck stops. But as of right now, it's just a communication issue to make sure it gets taken care of.
Thank you, Aaron. And we appreciate those questions and comments. So, okay, we're caught up. We can keep moving along.
Yeah, great questions. One I wish I had a better answer for, but certainly been batted around for generations now. Okay, going back to the public health structure that we currently have, and I have heard this as a rub now before everybody freaks out, because I think I've mentioned this as a rub a couple of times, and everyone says, oh boy, is that my commission? Are they trying to stir the pot and take us down or those kind of things? And no, I just hear it as kind of a frustration, but I haven't heard anything significant that this would actually change. But the current system, I can see where some county commissions have a little bit of a rub. So by county commissioner vote, they can vote to join a district or merge with a district or those kind of things. However, the statute says you can't withdraw once you've made that decision without a public vote. So that's always been a little bit of a rub. If a commissioner gets in and a commissioner 10 years ago said, you know what, we're going to join this public health district, and now 10 years go by, that commissioner's long gone. They don't feel like they're having the right service or whatnot. And I'm not pointing at anybody at all. This is just kind of the barroom chat you hear. And then the commission says, I would like to go to a different place. I'd like to dissolve this district and start all over. Well, technically, the law does not allow you to do that without putting it on the ballot. And so that would be a petition process where you would need 10%, and then you would ultimately have to have the majority of the voters vote to withdraw from that particular district. I've been doing this for 25 years, and I'm sure I've missed maybe one or two or something like that, but I'm not aware of a lot of withdrawals that have ever happened. So that's why I make the funny slide here about the mafia. It's kind of like once you're in, you're always in. You can never leave. Now, that said, there are opportunities in the statute that lay out if you want to leave and go somewhere else, that is a possibility. The law specifically requires that you have to be, every square inch of land in North Dakota has to be in a public health unit. So even if you are successful going to the voters to get out of your current unit or whatever your structure is, you would still need to then go and be in another one. And because I haven't seen this happen, and somebody can correct me if it's happened to them, I'd love to hear from you. Again, I want this presentation to be interactive. That's the only negative of the webinars, of course, as I mentioned, is it's not as interactive. But feel free to dive in if you've seen some pros or cons of this kind of structure. But I don't know how you necessarily set this up because, again, as I mentioned, if you want to withdraw from a public health unit, you would need to have the voter approval. And if you want to join one that does not require voter approval, but it requires the district that currently exists, they would all have to vote, the majority vote, to allow you in. So it seems to me that you wouldn't want to put on the ballot that you're leaving when you haven't already secured the new place that you want to go. Now, I suppose you could just create your own district. That would work too. And I think that's even been kicked around in the Burley Bismarck area here. But generally, standing up a brand new department would be very costly. So there's some practical limitations. But depending on how you got in, changes on how you could get out and where you should go to after that.
Question for you. If a county were to withdraw from a joint powers agreement with the city, would the vote of the people still be required?
Yeah, that's a great question, because that one isn't set up kind of the same way as the current structure. I would say a joint powers agreement probably could. Oh gosh, I can't quote that. I can see both sides. What I can tell you is there's no case law or AG opinion on that. I think on one hand, you could say a joint powers agreement isn't what is envisioned when it comes to the health district setup that's listed in 2335. And so therefore you could kill that contract and then start your own or merge with someone else. On the other hand, it is what it is, and the current law just says if you've been in operation for 2 years, you require a public vote to get out. But it isn't as specific on the history of how you got in. So I would need to work with local council to actually figure that out. That's a great question.
Okay, thank you, Aaron.
Yep. My general rule is, again, it's no sense in even talking about trying to get out or breaking a joint powers agreement until you've first secured the new place. And the new place, again, requires the county commission or city commission, whatever the structure is, to agree that you should even be in there. And of course, that means that you might end up being restructured, and you might end up paying more in property tax than you currently are. A couple of things I was going to mention too, just when we're talking about property tax and what everybody is paying. So going back, I looked at the health district fund that is used, which you have a maximum of 5 mils. So when you go back to that original slide, I'm not talking about the tribal structure here, I'm talking about just the county city structure. It appears right now, using the health district fund, that counties statewide levied $9.1 million. It looks like the average mill rate for counties is 3.05, with the lowest county bringing in 1.02 mils and the highest county bringing in 5 mils. And we have all of that listed. Now, I'm not sure, that's just purely looking at the mill levy for the health district levy. I don't know if there are other counties out there that just use general funds. In particular, I would guess maybe Burleigh County uses general funds instead of tacking on a health district fund. I'm not sure how everybody is set up, but it looks like about everybody takes half of the mills that are authorized. Again, if you were to jump out of one district and go to a new district, presumably the voters allow for that, you would have to look at those dollars and cents too. And you'd have to look, you might have been sitting in a district that's allowing you to go 2 mills, but now when they equalize all the mills at the end, you might end up going to 4 mills, and that might not be, your citizens might not like doing that. So again, we have all that information and we can get it to you. I am curious how much counties use for general fund or cities use for general fund funding of those. And if I remember last, when we talked to the public health folks, I think you have about $8 million that comes through the state aid that gets distributed too, which, and of course, then there's other grants and those kind of things. But when I look at the dollars spent by public health for what we get a real good bang for the buck in terms of a citizen. Public health is out there doing a lot of things, and they are not asking for a lot of money. So I salute you for keeping your ships running pretty tight. Okay. Just a little bit more on governance. The governance must have at least 5 members. And that's why I'm always, where I think it's kind of interesting when you're talking about a single county public health unit, because you could just have 5 commissioners on there, but there must be some benefit for a single to have 5 members that may not be county commissioners. I'm not sure. At the end of the day, for a single unit, you're getting your money from county X. And so you're still relying on those 5 commissioners, but it seems to be working. I have heard some public health say, well, we like it because then we have our own essential unit as opposed to just a department. And then you might not have to follow the same type of salary guidelines that the county sets up for all their employees. So I suppose that might be one, but the money's coming from the same place. And then, of course, as you all know, that the law allows counties or cities to combine in whatever manner you might have. And this is in the manual. We kind of laid out all the scenarios. If you have 5 counties and one has a city of 5,000, here's how your board should look like. Because the large jurisdictions get an extra vote on the governance, obviously as they should, because they will be paying the most amount of money. So I didn't put that in the presentation. That's just something you would work through. From what I understand is that current structure that's listed on page 2 or whatnot is all compliant with this. So that's not too big of a deal, but if you do want to look at how to crunch the numbers, we can look at that. And then here's where I get on my soapbox. You can't have your board of public health be all female or male, which I would guarantee there's a backstory there. I probably guarantee you I don't want to hear it because it would just make me mad. But I know of no other statute that dictates the ratio of males to females on any board in North Dakota. And so that's a little weird. And so that's my WTH. I was going to put something else, but I figured this is probably a public presentation, so I won't use the other one. But that got me just to thinking for laughs, I guess. If that would apply to county government, 35 of our counties would be not compliant with the law because 35 out of 53 for a 77% rate are all men. I can't imagine the uproar if you were to ever put in the county commissioner chapter that you couldn't have all males on the commission. Okay, that's all I'm going to say about that. That's weird. So I will move on. Most of this, it looks like we redid this chapter in 1999. I was not around at that time. And it looks like there was a lot that got transferred over from an older time period. So hopefully someday we don't have to look at male, female. We can just look at who wants to do the job. So, okay. Back to actual presentation. Now, remember when you put your board together, whether it's a multi-county, a single county, a city, county, whatnot, the public meetings law will apply to you. And I'm not going to spend a lot of time on this. That's a whole presentation in and of itself. But open meetings, open records will be applying for you. As all of you know, that means anytime a quorum of your board gets together, that would be an open meeting which you would need to notify. I've told a lot of people this in the past because I've heard people say, well, if this open meetings applies, that really limits how many times we can meet, and that's not true at all. You can meet a million times a day with all your board members. The only thing is you got to do is give public notice and make sure it's accessible to anybody who wants to come. So open meetings are not designed to not allow you to meet. They're designed to allow you to meet, but the other people get to hear what you're doing. Again, that apply to all the records that you keep. Those would be open records. Now, of course, in your world, dealing with healthcare and those kind of things, there may be quite a few exceptions that apply that you would not have to give out some of the things that you hold. But generally, you're going to have to give out information that's applying to the board and those kind of things. I also, and this is where I'm not trying to freak anybody out, because I know it probably happens and it's no big deal. But technically, if that board ever assigns a subcommittee, unless it's a subcommittee of one, so if that board says, you know what, we really want to look at our vaccination policies or immunization policies, but we don't want to do it with all 10 of us here because it takes too much time. We're going to assign 2 of you to go as a subcommittee and come up with a proposal for what we should do. Technically, that subcommittee would fall within the open meetings where you would have to notify that meeting. Now, if it's a subcommittee of 1, or if 2 people just decide, 2 people on a 10-person board decide to get together over coffee or beer or something and talk about it, then that wouldn't be a quorum that would require any type of notice. But just keep that in the back of your mind. And a quorum is, again, just simply the majority of whatever your board is. I didn't go back and look to see how many board members all of those districts have. I'm guessing they're probably in the, the 5 to 10 or 11 area. I'm not sure, but we'll find out after this, I suppose. Now, this was core functions was really helpful. I think all large organizations like public health, whether it's government or not, do need kind of some strategic planning to figure out exactly what they want to do, what they should be doing. And Mary Korsmo, the executive director of the SACHO, the public health group, was very active, along with, of course, all the rest of the public health group, to try to help define some of the core functions. And in particular, coming out of the pandemic, it was nice to start focusing up again so people understand that we're just not doing disease control. We have so many other things that are important to people. So I really do give you a tip of the cap to making sure you refocused. And so this is now in this Century Code, kind of defining what you should be doing. Again, didn't really change much, but it at least lets us go back when, let's say, the county commission is frustrated or something like that. You can say, hey, this is a core function that the legislature wants us to provide and requires us to provide. So we really need to do a good job at that. And again, here's some of the factors that all of you work on. What I'll say is, again, I've been doing county stuff for about 25 years now. Public health is probably the broadest, social services probably too, has to take care of the broadest number of things. Sheriff's deputies, state's attorneys, they're extremely busy, but they're very focused on enforcing criminal law. And in your world, you have a foot in a lot of things. And sometimes even the social service blends over with the public health and whatnot. And so you just have a very broad footprint, which makes the job a little more challenging, of course. A little bit of the frustration, again, when I was prepping for this, at first I just pulled one book off the shelf, the 2335, and I thought, wow, I can get through that pretty easy. And then pretty soon I was looking at the municipal codes in the 40, and then pretty soon I was looking at the 42. And then pretty soon I had almost every book in the Century Code books on my desk open. And it does get a little bit wonky, I guess. But again, that goes back to the beauty of decentralized government also. That in particular, just one of the things that I kept bumping up against is public health has the duty to deal with nuisances. But guess what? So do the cities. Guess what? State's attorneys can bring criminal charges for nuisances. The attorney general, a private citizen, can bring action for a nuisance. So there is a ton of overlap, and that's probably a good thing, because maybe you have a local government that's not staffed up to do the job, but you could have the state health officer step in, or the attorney general. So there's a lot of overlap, which can be frustrating. And part of that, I did identify a couple of statutes that seem, depending on whether the health board is taking action, or depending whether the health officer, the state health officer, is taking action, it might have a different remedy, which is a little weird. I would guess at some point we should spend some time identifying those and making sure they're more consistent, and still maintaining a broad category of people who can enforce the law. And of course, speaking of nuisances, this is actually a photo taken from the Fargo Forum. If you haven't recognized this, this was an ongoing dispute for a couple of years. I think that this was the city of Fargo that was undertaking this nuisance and not the Cass public health, local public health. This house ultimately was torn down after apparently it appears to be years of negotiation with the owner. The owner ultimately was also arrested when he was trying to interfere with the city doing the job of tearing it down. And I think just about a month or two ago, he was convicted. Dan Curtis was convicted of interfering with this nuisance. Now, of course, the Fargo Farm was probably trying to sell some newspapers because this photo doesn't look so good. This photo doesn't look so bad. And they say they tore it down, so you probably are more sympathetic to the individual. But I would guess they didn't, well, I can tell you, they never posted any pictures of what it looked like inside. They did post some in the backyard, and that was, of course, a disaster. Most of the nuisances that, of course, you deal with will be, dilapidated homes and those kind of things. If a home like that was sitting next to my property, I'd be pretty upset too. That said, of course, we're individual rights state too. And so you got to really thread the needle on those kind of deals. The Curtis family has had a long, in fact, I go back probably 20 years ago where I charged Ed Curtis, that's his brother, with defrauding a bank. So that family has gone through some tough times for a long time. Ed Curtis, for 15 years after that, sent me threatening emails. But I didn't feel too bad because he was sending it to every lawyer in the state. I haven't got one lately, but I think we just updated our spam filter, so maybe that's what it was. But again, the nuisance chapter is listed. The nuisance steps are listed fairly cleanly depending on who is doing the action. Now, of course, the nuisance allows you to put any of the cost of demolition, and including there's an AG opinion on attorney fees and any other fees that could be associated with this. Not the litigation fees, but if there was an attorney you had to consult, that can be stuck onto the property in terms of a lien against the property, which again, in legal sense makes a lot of sense. But for all of us who practice in this world, doesn't make a lot of practical sense because, of course, if it's a nuisance property, it's probably not that valuable. So you're going to spend whatever, $50,000, $100,000 to take down a building that's probably worth $50,000. So you're going to lose money. So putting a lien against that property is going to be a cost loser, which means somebody's going to supplement that because you have to pay the contractor. So then either the city, if it's in the city, is going to pay that cost, or the county if it's in the county. And we have an AG opinion, that's that 2005 L16. You can find that on the AG's website in the opinions section. Again, I suppose you could have agreements between political subdivisions to handle that differently, but that would be the general rule unless you have a different agreement. I'm assuming from the public health folks that I've talked to over the years, the nuisances can be the houses, it could be the junkyards, or you could be a farmer who just keeps accumulating stuff, and now you have rats running around and all that kind of stuff. It's not a particular clean process, especially if you have to involve bringing the state's attorney on board to help you with any legal proceedings. Judges don't particularly like these cases either. You would hope they end before somebody fights an officer and somebody gets hurt. But what I've seen is generally that's where it really hits the fan. And hopefully, hopefully it just ends as a disorderly conduct like Dan Dan Curtis, and not anything worse. I don't know if there's any questions on nuisances.
Not at this time.
Okay, couple more things. Going back to some of your authority as public health, local public health actually has the power to go into businesses or homes or anything to search that there would be anything related to some sort of public health filth, those kind of things. Obviously, a house full of rats and all that kind of stuff, hantavirus, those you could go in and identify those issues. Now, the statutes are pretty clear, and again, this goes back to kind of the Fourth Amendment. We typically think of the Fourth Amendment as law enforcement related, but it also applies to any government actors. The law is specific that even public health has to follow a warrant type process if you can't get a voluntary consent to go into those places. So again, if it's some sort of rat infested house, those kind of things, you could ask permission from the landowner or the person staying there. And if they give you permission to go in, you certainly could go in. If they say no way, then you're going to have to go through what's called the administrative warrant process, where you apply to a judge. The administrative warrant process is different than what law enforcement uses, which is a search warrant process. Law enforcement is required to use a search warrant when they're enforcing criminal law. And in order for a judge to sign off on a law enforcement search warrant, they need probable cause. So the officer has to come in and say, it's probable Aaron is dealing drugs. It's probable he's dealing drugs out of his house at 4801. And we want authority to go in there and look for those drugs at 4801. The administrative warrant process is different because there is no probable cause standard. The administrative process is you would have to go in and lay out that there's a possible health filth, kind of the sewer is bubbling up and spilling out into the public waters, those kind of things. You don't have to tie it to any criminal activity, but then a judge would sign off on that. And the only real thing I want to highlight on this is you only have 24 hours to use that warrant. So this, of course, would be the last stage. Most public health that I know tries to work with the landowner and those kind of things to make sure they can get consent. And if not, this is the hammer. This is where you go to the judge, and then you just bust into their house. Now, of course, you don't want to do that without law enforcement with you. So the statute specifically identifies law enforcement will help you on those kind of administrative searches. The benefit to the individual, of course, is if you're not using a search warrant and you're trying to pursue criminal activity and you're using an administrative warrant, then the statute specifically says, well, because this wasn't a search warrant, we're very much going to limit the government's ability to use that information against the individual in criminal and civil actions. We're going to let you go into the house under a lower standard, essentially, but it's to enforce health law and not to try to put him in jail and those kind of things. Again, if you ever get to this point, I would assume you would be working closely with your state's attorney. Feel free to give me a ring if you ever get to this point. I haven't heard of a lot of these ever happening. Most of the time you're dealing with a nuisance property, you're dealing with probably somebody who might be elderly or somebody who might be suffering some mental illness. They're not bad people, they're not criminals, slinging drugs, but they just can't keep up with what they're doing anymore, and they're willing to work, but they just have some issues. This is, every time I think of this, I think of that show Hoarders on TV, which I watched like maybe half of an episode, and I just can't believe people can live like that. So I get creeped out even watching it, but I know it's out there. Of course, all of you know it's out there because you're dealing with it. So thank you for dealing with that. Okay. And of course, this was the big one coming out of the pandemic. All of the authority you have dealing with infectious diseases. We tend to think of infectious disease as the tuberculosis and those kind of things, there's quite, as all of you know, quite a list of what qualifies as the infectious disease. All of those are required if they fall on that list, that you must report those to the state. And then you have the ability for certain things for those diseases to quarantine. And of course, during the height of the pandemic, we were dealing with this on the state's attorney side, trying to figure out exactly when and where you should use the power to quarantine. I don't think it happened. It might have happened one or two places, but it was rare because, again, this is going to be one of your last options working with people to keep them healthy. But certainly, the statutes have to allow the government at some point, we can debate where that point is, but at some point, there are some things that the government has to have the ability to step in at the unfortunate cost of an individual, but on the benefit to society. So that is why these exist. I don't anticipate them ever going away. They could be modified slightly on when they could be used, when they can't be used. But ultimately, everybody in society understands there is a potential that there could be something so problematic to everybody's health that you have to act. And of course, this is where it comes in. You try to do the voluntary thing, but ultimately there is a hammer here that the law enforcement can use. And that is, you could be charged with a Class C felony, which means you could go to jail for up to 5 years. And this happens. I actually did a case in Cass County on tuberculosis in about, I don't know, 2004 or something like that. We had an individual who was homeless, who had tuberculosis. Dr. Beard said he's no longer compliant. He's not taking his medications. He's hanging out with other homeless individuals and spreading the disease. He refuses to work with us. And so actually I did charge him with a Class C felony, and he was arrested and put in the Cass County jail. You don't want to put those folks in any jail. You have to have a negative pressure on the cell that they're in, because you don't want everybody else getting tuberculosis or those kind of things. Ultimately, he was convicted, and then the judge sentenced him to more incarceration, and then changed her mind and let him go. But it turned out okay at that time because then he realized he needed to take his treatments, and then he was compliant with Dr. Beard for the minimum period that he stayed alive, because I think he died not too long after that. But there is hammers that the government can use, and again, I don't advocate, and that's got to be the absolute last stop. But yeah, so if anybody ever needs a charging document, I got it. State versus Michael Machipness. I appealed, so not to talk war stories, but I guess I am. He was convicted, sentenced. The judge had never heard of him, Judge Georgia Dawson. She was a fantastic judge, good human being. Said, I've never seen anything like this. I'm uncomfortable with it. And on her own, without the parties present, redid her order and told the jail to let him go. I found out about it that next morning, had a bit of a freak out session, and appealed her to the North Dakota Supreme Court that her sentencing was wrong, which it was. And then when Dr. Beard said he's compliant, I withdrew the appeal. But that's the process of that one. That was a weird one. Yeah, I got this question a little bit while we're talking about kind of reporting and those kind of things. Once in a while, again, social services blends with public health. So if public health ever runs into a scenario where you see child abuse or neglect, again, that could be a kid living in the rat-infested house, those kind of things. That could blend into your world. Technically, you're not a mandatory reporter if you're just a public health administrator, but if you are a medical professional, you would qualify in that neglect, and you would be required to let social services know, and that's called filing the 960, the mandatory reporter. So you would fill out that form. again, the public health officer might come across those and you would be required to report. The other folks that are working in public health probably are not on the mandatory list. I would have to look at what position it is, but you still have the ability to discretionarily report. Additionally, anyone who reports under the mandatory reporting or discretionary reporting of child abuse or neglect is immune from civil or criminal liability in the normal course of action if it's in good faith. Obviously, if you're making up stories, that's a different story. But if you find a kid in a rat-filled, filthy place, that would fall within your ability to report. And kind of one of the final slides that I'll wrap up with and take any questions that you have is septics. Obviously, public health is involved in the transportation of waste and making sure waste is treated properly. Public health, state health, of course, deals with the livestock and the animal feeding operations and those kind of things. But when we're talking about houses and those septic systems, that falls to the public health entities. This is where I need to apologize to the public health folks that were sitting on, who were sitting or currently sitting on this technical advisory committee. So back in the 2000s, we were seeing that statewide, there were some public health units that didn't have any septic code and some that did. And it seemed like all across the board, and some of the installers were getting frustrated because in one jurisdiction, they were required to do X, and the other, they were required to do Y, not to mention pay different fees. The installers that I was speaking to agreed that there needs to be regulation, so it wasn't a no regulation kind of crowd. And so I thought it would be easy for public health to get together with some of those installers and ultimately have kind of the backing of the law to come up with what the actual code is. This had been going on for a number of sessions where installers were coming in with a 100-page bill trying to identify what the code should be. And that made no sense. Those bills always died because you can't put everything in the Century Code when it comes to slope of pipes and all that kind of stuff. That just didn't make any sense. So the thought process was in 2021 that we would create a technical committee made up of regulators and installers. They could come up with the ideas of what the code should be, and then they would send that down to local public health, and then local public health would adopt those codes, and everybody would be generally on the same page. Well, I think some personalities, not from the regulator side, but some personalities on the installer side, made it not as easy as I thought. And so again, I apologize if that was frustrating to a bunch of you. I still think if I step back and look at it, 90% of what was talked about seems good policy, but there is definitely some confrontation on some of the others. But hopefully we can kind of keep grinding that out and get it done. So I think everybody would agree if you have regulations that are absurd or those kind of things, you drive things underground and then you have worse outcomes. And we don't want to go back to the days of course, people just digging a hole and putting a used car in the ground and using that as their sanitary system. So again, hopefully we can get that all squared away, but God bless you for sitting on that and trying to get it done. So those are that's an outline of where this manual is going to be and some of the things we've identified. We're certainly add to it as all of you give us ideas. And I hope in the next couple of months, we'll have it finalized so everybody can start throwing in on that. But I'd be more than willing to take any questions, comments, or you can always email me and I'll try to get back. Well, I will get back to you. It might not be right away, but be more than happy to take any questions.
All right, thanks, Aaron. You covered a lot of ground here. And yes, let's take some questions, comments. Aaron, this question reads, can a public health department not hire an employee based on the prospective employee refusing to take the COVID vaccination or the flu shot?
So whether you could require an employee to take the flu or COVID. Most court cases that I've seen, I can't give you a definitive answer right now without looking a little closer at that issue, but I would say most cases have always backed up the political subdivision when they have a basis to require that employee to have the COVID or whatever vaccine for that matter. If it's just a position that would have no exposure to people with COVID, those kind of things, then the courts generally say your reasoning isn't good enough. But if it's, let's say, a public nurse that's going to be out dealing with people with infectious diseases, courts have got the back of the government when they require that. I will look specifically at that.
Thank you, Aaron. Well, I don't see any more questions. Do you have any closing comments before we wrap up?
The only thing I would say is you all have tough jobs. Thank you for what you're doing. And I know we're going to have better days ahead for public health where everybody can rally around the team.
All right, thanks so much, Aaron. And a big thank you to all of you for carving out some time in your busy days and joining us this morning. As we close the webinar, for those of you viewing this live webinar, a quick evaluation should pop up on your screen. So thanks again and have a great rest of your day. Take care.